All right, peace to the gods, peace to the gods. Yusef here. Got another show lined up for you. Another show lined up for you. All right, yeah. How's everybody doing today? Let me let y'all get on in for a little bit. Let's start talking about this today. We got a part 4 dealing with presentments. If you've been hanging with me so far, you know, on a daily basis, I've been going through this document. I'm going real slow through the document because there's so much information to be absorbed. Peace to the gods, peace to the gods. Hit the like button as you come in, and also if you haven't joined the channel, join the channel and make sure you hit the notification bell. Click all notifications, check all notifications. That's going to have the analytics of this channel. It's going to have the channel grow. Peace, God, peace. Peace to the gods. All right. Let's get to it today. We got a part 4 of dealing with presentments that we're going to talk about today. You know, if you haven't read Dealing with Presentments, it is a very good document for you to read. It is one of the first documents that I ever read on this particular subject. It helped me get a great understanding of what I was doing. I utilized a lot of the things that were in that document and had success, and that is why I'm sharing it with you. My understanding has grown significantly since I first read this document. However, so I can pull out all the salient points, direct you to the principles that you should be observing, and just very good information, just good, solid, basic information if you're new to this space and you're trying to learn some things. Peace to the chat room. How do I restart my SBC account? It's been closed for a year. Email my customer service. And we'll get that restarted for you. Peace to the gods, peace to the God. Like that, y'all. Okay, we got people coming in. All right, so let's get to it. Let's get to today's lecture. I'm just gonna get straight on into it. All right, straight to it. Okay. Make sure I got this going. Let's get to today's lecture. Okay, all right. Okay, all right. All right, so I got the document up on the screen. Dealing with, and we left off, we were right here. We were having a discussion about the incorporation of the United States, or whether the United States is a corporation. There's actually a video circulating on Instagram where one of the generals called the United States a corporation. He said this corporation, he called it a corporation right in front of their face, right on the Senate floor. I'll get that video and bring it to your attention. But it is very imperative that you understand the United States and how the United States corporation operates. As a matter of fact, let me direct you to a document that you should need to read first. It is called Outline of the Constitution. Let me bring that document to your attention too. Outline of the Constitution. All right. This document is called the Outline of the Constitution. Outline of the Constitution. And let me see. Let me close some of this other stuff. I need to close some of this stuff. All right. Outline of, let's see. All right, outline of the Constitution. Okay. Now, this document right here, what is this document? This is a document. This is the result of some research that I conducted. And I'm going to explain this document because it is a very important document for people to understand. It is a result of my own research as guided by other independent researchers. You know, when you come into this game, you hear that there are two constitutions. There's a constitution for the United States of America, and then there's the Constitution of the United States. And a lot of people will complain, well, I can't find a constitution for the United States of America. Well, yes, because it used to be on the internet a lot, but a lot of stuff just disappears off the internet over the years. It just does. That's another reason I started SBC University as a repository for information, because I download everything off the internet and save it, because things come up on the internet come up missing. I made that mistake. It's a lot of good videos are on YouTube that are not on YouTube any longer, and I wish I had downloaded them and saved them. And I used to actually teach classes off of YouTube, from videos off YouTube. That's how I know what I'm talking about. But anyway, a lot of individuals who were, they're talking about the United States of America is a corporation. You hear people say that. Okay, so that was told to me as well, that there were two constitutions, the flags in the courtroom, the Admiralty flag. You heard people talk about all of that. So I had to do a deep dive into that subject and to really come to an understanding of, is there a corporation and is there some sort of difference between a republic and then the corporate democracy? And yes, there is. Yes, there is. And it is apparent. And how they have managed to pull this off is because they have an understanding of the principles of the Constitution, most importantly, separation of powers. Separation of powers means that each of the individual branches of government have what is called plenary power, as long as they're exercising that power within the framework of the delegation of powers that are given to them by the Constitution. So as long as the Article 3 judges are doing what they're supposed to do, no other branch of government can say anything to them. They're like all powerful. Well, that same thing holds true for the legislature. As long as they're exercising those powers in Article 1, Section 8 of the Constitution, they're all powerful. That constitutes a territory in which they have like godlike powers over. So within that territory, they can do whatever they want to, which they have. They have put in a Federal Reserve System in that space. They have created another form of citizenship called a U.S. citizenship. They have created a welfare state within that framework. They have what is called a democracy within that framework, even though under Article 4, Section 4 of the Constitution, we're guaranteed a Republican form of government. I had never heard the word democracy before. It's not in the Pledge of Allegiance. It's not in the Declaration of Independence. And it's certainly nowhere to be found in the Constitution for the United States of America. So in understanding this, there were a couple of things I had to research. First, I had to start by researching the word Constitution. Okay, that was an important word to look up. And I found under parliamentary law, which is law that governs legislative bodies, I found out that they can create a corporate entity. A constitution will create a corporation. They're used to create corporations as well. So this ambiguous language that they use, you have to be able to decipher the meaning that they are attaching to something. Sometimes this is signified by capitalization and lowercase words, from a proper noun and a common noun perspective. But there are a lot of different things you have to, when you're reading law, you have to be very, very, very knowledgeable about the 8 parts of speech. You have to understand grammar. It's a language in and of itself, and they couch a lot of the meaning behind the things that they do are in the grammar that is being used a lot of times, okay? I cannot stress the importance of that. A lot of gurus don't pay attention to that because they didn't pay attention in high school or anything. They didn't think it was important. And now they're coming into this space and they have a very weak foundation when it comes to grammar. Okay. So, yes, essentially, now, when we're looking at this, you see this as the Constitution for the United States of America and the Constitution of the United States. The word our country is not called the United States. The name of our country is America. Okay, that is very important for you to understand. United States is a description of America. All the states in our country came together. Okay, the United States of America. Okay, the United of is a preposition. But United States is a proper noun. That is the name of something. The United States. That is the name of something. Okay, like Federal Express. That's a name of something. One is describing something, and the other one is the title or name of something. So once again, so they say they don't use of America on anything that they have. It's the District Court of the United States, United States citizen, United States Postal Service, United States District Court. Everything is United States. So that right there is a clue as to what you are dealing with. You're dealing with something that solely belongs to the legislature. The legislature. Now, a lot of us are under the impression that statutes constitute some sort of law. That's what attorneys will tell you, that the statutes are law. Well, they are a law, but they're a law that operate within a certain jurisdiction, the jurisdiction of the United States. So we have to clearly define, well, what is the jurisdiction of the United States? Well, let's look at it right here. It says under Article 1, Section 8, Clause 17, the legislature is authorized to create a separate entity entitled United States. United States Code Title 28, Section 302.15 defines United States as a corporation. This corporation has ultimate authority over all territories under its jurisdiction and exercises legislative, executive, and judicial powers within over such. Now, this is what I want you to understand, that each of the branches of government has their own court system. Within the legislature, they are self-contained. They have within their framework a little smaller legislative, executive, and judicial type of powers that they exercise within their branch of government. They exercise legislative power, of course, because they have the statutes. They exercise enforcement power of that because they delegate power to the executive agencies to have them enforce their statutes, like, the DEA, Homeland Security, etc. Those are executive agencies, but they're enforcing statutes for the legislature, even though there's a separation of power, because the legislature delegated power to the executive. Okay, it's called delegation of powers doctrine. You need to read that and you need to understand that in order for you to understand what I'm talking about right now. How the branches of the legislature delegates powers to the executive and to the judiciary. That's why you have a judicial committee. That is the legislature delegating powers to Article 3 to have them draft things like sentencing guidelines and things like that. When, Antonio Scalia, he said he didn't even believe that was constitutional because of separation of powers. You need to be doing that for yourself. But it was smart for them to do that because that way they can make sure that when they draft a legislation, there's nothing unconstitutional in it because they've had the Supreme Court justices oversee it. I understand the reason for doing it, and it is a good reason for doing it. But anyway, what you need to understand is when you subject yourself to a statute, you are coming into a different type of jurisdiction. You're coming into a territorial jurisdiction. You're coming into an agency court. This is why they call the administrative agencies the fourth branch of government. I want y'all to write that down. Administrative agencies are the fourth branch of government. The reason why administrative agencies have become the fourth branch of government is because you are called a U.S. citizen, and you don't know what a U.S. citizen is. A U.S. citizen is a federal citizenship. Your true citizenship is from the state you were born. You're either a Texas citizen, Florida citizen, citizen of the Republic of Texas, citizen of the Republic of California, citizen of the Republic of Illinois, citizen of the Republic of Florida, because you were guaranteed a Republican form of government, Article 4, Section 4. So what are you a citizen of? Repeat it together. I am a citizen of the Republic of Texas. I'm a citizen of the Republic of Georgia. I'm a citizen of the Republic of Illinois. I'm a citizen of the Republic of New York. I'm a citizen of the Republic of Louisiana. I'm a citizen of the Republic of Washington State. I understand this. You got to understand you were guaranteed a Republican form of government, and you need to understand how you can get back in that particular jurisdiction, because you are not operating in that jurisdiction, because the republic is a house no one lives in, because everybody's going around calling themselves a U.S. citizen, not knowing what that is. A U.S. citizen didn't even exist until there was a 13th, 14th, and 15th Amendment. Okay, so let's look at this again. So right here, you can see this is the organic Constitution, the Constitution for the United States. So you have an Article 1, legislative branch, Article 2, executive branch, and Article 3, judicial branch. These are the organic, the way it was originally set up. What happened was the legislature set up a federal corporation and called it United States. So the United States, this is where under UCC 9- I forgot the location of the debtor. Okay, it says that the United States is located in Washington, D.C. That is true. Washington, D.C. is not a state. It is a territory. It's not one of the 50 states. Okay, it is a territory. So when they made you a citizen of the United States, they made you the citizen of a federal territory. Within that territorial framework, Congress exercises plenary power. That's why it appears that you don't have any constitutional rights, or it appears that the legislature is acting like they're God over you, instead of in the capacity of a public servant. You run around scared of them and everything like that, because you are running around within their jurisdiction. You're using Federal Reserve notes, which is the monopoly money that they issue within their jurisdiction. Once again, to illustrate, it's just like if you operating in if you going into, what is the store I'm trying to think of? What is that store? I'm always thinking of it. Like a Sam's Club. Okay, if you got a Sam's Club card, okay, you can shop in Sam's Club. Okay, well, it's like that in the United States. You need a United States card. And the United States card is a Social Security card. You got to understand, they operate just like a regular corporation. They're doing the same thing. They have membership cards. They issued everybody a membership number. And as long as you have that membership number, you can access benefits and privileges within the United States. Now, we got to understand, what are all the benefits and privileges of the United States? Statutes, the utilization of their statutes, their private copyrighted, and their statutes are copyrighted as well. They are copyrighted, utilization of their statutes, utilization of, incorporating your business, and the access to the police department, or, the FBI, anything that you utilize from them, that constitutes a benefit and a privilege, and that's what you're being taxed for, government services. Okay, so we are lobbying, or we out here fighting. I'm a private property advocate. That means that I don't want big government. That means I can never be a Democrat. Don't have anything to do with Donald Trump, has everything to do with my understanding of civics. Okay, I'm for private property. Okay, private property is where you have freedom. If the government is in control of everything, you don't have any freedom. You're under government regulation. Anything that the government funds, they're going to regulate. Anything that the government, anything associated with them. That Social Security number was created by Congress. Okay, so when you utilize that Social Security number, they are allowed to presume that you have some sort of status that requires some sort of reciprocal obedience. Okay, they're giving you something, but you got to give them something in return, meaning that you have to follow all the rules, regulations of the corporation. And you've done this tacitly because millions of times you've signed on applications, I'm a U.S. citizen. So within that legislative United States, this is the legislature, they exercise legislative, executive, and judicial power. They have their own court system as well. That's under Article 1, Section 8, Clause 9 of the Constitution. They have the ability to constitute tribunals that are inferior to the Supreme Court. So all this is operating within the framework of Article 1. All this that you see right here, this is Article 1. To understand how it all comes together, you need to understand plenary power. You need to understand separation of powers. You need to understand delegation of powers. You got to understand these things so you can see clearly how the United States is a separate entity from the United States of America, and how they use a play on those words. And trust me, all the Supreme Court justices acknowledge this. All of them do. This is not some sort of conspiracy theory information. Okay, there is a document you can get off SBC University. It's called the Federal Zone. It is right there on SBC University for free on the download section. You do not need to be a member of the website. It's right over there right now. If you want to understand the 3 different types of meanings associated with the word United States, it is there within the first 4 pages of that document. And they give you the case law to support it. Now, here, how I broke this down, when they exercise legislative power, which means they are making their statutes, codes, rules, and regulations. Okay, these are the definitions of what a statute is, a rule, a contract, all these things. This right here is the definition I pulled out of Black's Law 4th edition of Constitution under the 4th sense of the word under parliamentary law that I was talking about earlier. Okay, when you read this, you begin to understand that the word Constitution has another meaning. It can mean a corporation. Constitutions are utilized to form corporations. All right, I'll read it for you. It says parliamentary law, a governing document adopted by an organization for its internal governance and its external dealings. The Constitution may be an organization's most authoritative governing document, but if the organization has also received a charter or adopted articles of incorporation or association, then the Constitution is subordinate to them. If the organization has also adopted bylaws, then the bylaws are subordinate to and usually more easily amended than the Constitution. The Constitution and bylaws are sometimes contained in a single document, which is the case that we're dealing with. The bylaws of the Constitution, the different articles are contained in that document, and it looks exactly like the organic Constitution. They just copied the original and made a different, to form this corporation. And you find this, you can read the Federalist Papers and the Anti-Federalist Papers. It's mentioned in there that the United States is a corporation. It's in a lot of different places. So please don't think it's some sort of conspiracy theory. All right, they have formed some sort of corporation, and that national debt, because look at what the debt is, the federal debt. The federal debt is to the Federal Reserve. We borrowing Federal Reserve notes. Okay, Federal Reserve notes are not constitutional script. Debts have to be repaid in gold and silver. Because we don't have any more gold and silver, okay, what they have done is they've pledged all the property in the United States as well as all the citizens, the labor of all the citizens. So the United States is operating in what is called, they're in bankruptcy is what they're in. All right, receivership. They're allowed to continue to operate even though they're they're $35 trillion in debt. Okay, now, that debt is not your debt. That's the debt of the United States. How they made you a party to that debt is by giving you a social security number. That's what the New Deal was all about. The New Deal was all about creating a system where government officials can go and borrow money for the Federal Reserve and hold you as a surety for that, where you'd have to repay it and go to work and repay it. That's what the New Deal was all about. We'll take care of you, but we have to go and borrow money from the Federal Reserve in order to create welfare programs for your benefit. That's what they're going to tell you. They're being created for your benefit. I don't understand how giving money to Ukraine and Israel is for my benefit. They said they're for our allies. We don't need to be giving any more money to you. That's why they don't like Donald Trump. They don't like Donald Trump because he's not going to do that. He's not going to do that. He's going to cut all that money off that's going out of the country. Y'all really have to take a long look at the Democrats and to stop following. That's why all they do is pump in your heads racism, racism, racism. And you fall for that bullshit. All the while they laughing behind your back, getting rich, telling you to watch out for rich people, and everybody over there is rich. Michelle and Barack worth $70 million. Oprah on the stage saying no trust rich people, and she worth $3 billion. They just laugh at you in your face. They just think you stupid. I appreciate the $9.99, John Karbowski. I appreciate that, the $9.99. Appreciate that. And I also appreciate the $1.49 play. I appreciate all money that I get. Thank you for that. All right, so you really want to read this. Now, right here under the executive power is where administrative law comes in. You are subjecting yourself to administrative law when you call yourself a U.S. citizen. This is the enforcement branch of the legislature, that they delegate powers to the administrative agencies of the executive branch of government to do their bidding for them. Okay, you need to understand this, all right? So So here are all the agencies: Department of State, Department of Treasury, Department of Defense, Department of Justice, FBI, Department of the Interior, Department of Agriculture, Department of Commerce, Department of Labor, Department of Health and Human Services, Department of Housing and Urban Development, Department of Transportation, Department of Energy, Department of Education, Department of Veteran Affairs, Department of Homeland Security, and United States Secret Service. All these are under Article 2 of the Constitution, the executive branch. But they come over here and do the bidding. Like, for instance, at the airport, you got Homeland Security. But Homeland Security is what? They are a Article 2 executive agency, but they're over there enforcing because those are commercial flights. And legislature has the ability to regulate commerce under Article 1, Section 8, Clause 3, the Commerce Clause. So in the enforcement of commerce, they go and hire them some hitmen and they operate in the airport for them. That's called delegation of powers doctrine. You got to understand all this, how they are acting like a country inside of a country. Only because, and they're only able to get away with it because of your status, that you have left the confines of the republic and chosen to embrace a democracy in which you are a welfare recipient. That's why every time you see the Democrats, they're trying to talk about giving you something. Health care, welfare, Obamacare, Biden care, Bidenomics, whatever. It's giving you some sort of benefit, and you've been conditioned to receive that, and you think you have some entitlement right to it. And you keep forgetting that these are benefits and privileges. That's why they're giving all this stuff to the, and they're probably rationalizing giving all this stuff to the illegal people who come over here, because they're going to come over here and do the jobs that a lot of Americans don't want to do, and that's going to be good for the country. So they feel justified in giving them money and, giving them, shelter and all the things that they're doing over here. However, they're not following the laws of this country. If somebody's going to come into this country, they have to be documented. They have to follow the proper channels to come into this country. I can't believe that people are sitting around allowing Biden and, Kamala Harris to get away with that. I can't believe it. When they see they can get away with something like that, they know that the American people's constitution is weak. And they'll try something else next. That's all they keep doing. It's like the frog in the boiling water. They turn up the heat real slow. They just keep testing you and see how far they can get away with things. They just right in your face let tens of millions of people over into the country illegally. It's crazy, man. It's crazy. Then, of course, we have the judicial power that they exercise. These are your Article 1 courts. Write that word down. What is the difference between an Article 1 court and an Article 3 court? An Article 3 court is the Supreme Court of the United States of America. And you have two Supreme Courts, too. You have the Supreme Court of the United States of America, and then you have United States Supreme Court. I want you to start paying attention to the verbiage of these different entities. One was created by the Judiciary Act. Now you have to ask yourself a question. If the Constitution of the United States of America created the legislative, executive, and judicial branches of government, then please tell me what a judicial act is creating. Because an act is an act of Congress. And we have separation of powers, so they couldn't create their opponent. They didn't create, we have checks and balances. They didn't. They created what is called the United States, and they fill it with judges who are receiving a delegation of powers from them, and they're exercising in the capacity of an administrator. And that's why you see right here, administrator, when acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting in an administrative officer and not in a judicial capacity. He can't be acting in a judicial capacity because statutes don't belong to the judiciary. They belong to the legislature. Under the judiciary, they have what is called stare decisis. They follow precedent. That's called judge-made law is another name for it. Write that word down. Judge-made law. Judge-made law, common law, and stare decisis all mean the same thing. You got to know these things. You got to understand. You got to get a foundational understanding of these things first before you go on any kind of attack, before you are attempting to discharge any kind of debt, before you're trying to seek any kind of remedy, whether real or imaginary. You need to understand these basic things I'm talking about first, because they're going to order your thinking. You're going to be able to think properly. All right? You're not going to go into the courtroom and argue bullshit like you don't have no jurisdiction over me or, and things like that, just things like that. You'll understand how they obtain jurisdiction. You'll understand what a minimum contact is. You'll understand where you were at fault. you'll understand what is needed from you in the form of notices to sever any type of or rebut any type of presumption about your status. You'll be able to draft your documentation because now you got a clear understanding of the demarcation line that separates their jurisdiction from yours. And you can understand, well, what is the nexus between me and them? And the main one is the social security number. All right, so we're going to talk about that a little bit, but you needed to understand this. This right here is outline of the Constitution. This is a diagram to make you understand how the United States operates within the Republican form of government. The Republic hasn't gone anywhere. The Republic will always remain. It's just that people are not functioning in the Republic because they don't know how to access it. And the first step in accessing the Republic is that you have to give up all benefits and privileges from the government. I appreciate the $1.99. Truth is beauty. I appreciate that. Okay, so let's get further into this a little bit more. Doesn't the district include the bodies of water, including rivers that surround? No, what does that have to do with anything? That's admiralty. We're talking about territorial jurisdiction. All right, what are territories? You know, people ask questions and like, what are you talking about? You know, you need to find out the definition of a territory. What is the territory of the United States? It's outlined. I'll answer it for you since you don't want to read the Constitution. It's all the forts. Let's read Article 1, Section 8. What is the territorial jurisdiction of the United States? Article 1, Section 8, Clause 17. Let's read it. I know some people don't want to read it, so let's read it. Let's see what it says. Article 1, Section 8. The Congress shall have the power to exercise exclusive legislation. Notice this word, exclusive legislation. That is where they get the doctrine of plenary power from. They have the exclusive legislation in all cases whatsoever over such a district not exceeding 10 square miles, that's Washington, D.C., as may by cession of particular states, and the acceptance of Congress become the seat of government of the United States, not the United States of America. And to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And hold on, let me get the rest of it. This right here, the jurisdiction of the courts of the United States must be derived from the 8th section of the 1st article and 17th paragraph of the Constitution of the United States. Here it is, which gives to Congress exclusive legislation over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. That's your district courts. That's Guam, Puerto Rico, American Samoa, and also the Social Security number. The Social Security number is their territory because they created it. That is their document. So when you're using it, you're presumed to be under their jurisdiction. This is People versus Godfrey. This is a very good case. You need to read this case. You can understand the jurisdiction. See, for you to challenge jurisdiction, you need to understand their jurisdiction. Instead of going into the courtroom saying you don't have jurisdiction over me, you're making a conclusion of law without, any facts to substantiate it. So you have to do a little bit of fact finding, and to do that, you need to ask them some questions. Is this a civil or criminal action? This is a criminal action. Thank you. Let the record show that the action being brought against the defendant is a criminal action. Now, I have another question for you. The Constitution for the United States of America only grants this court 2 criminal jurisdictions. One is under the common law, and other constitutes a condition of contract in the criminal aspects of a colorable admiralty jurisdiction. Now, sir, would you please tell myself and this court under which 2 of these jurisdictions you're trying this criminal action? That right there is a surreptitious way of asking them, is this an Article 1 or an Article 3 court? Because the 2 criminal jurisdictions, one is under Article 1, that's the colorable admiralty jurisdiction, which is using a criminal, it's civil in nature, but it's a criminal action. And then they have a criminal action under the common law. One requires a injured party who is sworn at an affidavit of complaint, and the other requires a contract. This is why you keep hearing everybody say, well, where's the contract? Could you please put it in evidence so I can examine it and make a determination of how I am obligated to perform under said contract and whether or not I'm even a party to it. There's some sort of adhesion contract. Now, they have something called the Ashwander rules, and rule number 6. They won't tell you this, but they take silent judicial notice of the fact that you are an acceptor of benefits and privileges because you have a social security number. This is the reason why when they arrest you, before you ever see a judge, they fingerprint you and do a background check on you. And once they get all that information, they know for a fact they can take you into their court because you have a social security number. Even when you get pulled over on the side of the road and you don't have your driver's license, the first thing that a police officer is going to ask you for is your social security number. Okay? I know my neighbors like, nigga loud. Anyway. All right. So where are we at? Okay. So we're going to get, so I think that preference is what I'm going to talk about today. Let me see what we got in the chat real quick. We're not sending cash to Ukraine. We are sending old military equipment that would be more expensive to dismantle and calling it billions. That's BS. All right. They're not just sending just military. If you think that, you're crazy. And for every new department, you have to take 2 out. I don't know that. And stop checking the U.S. citizen box everywhere. It's hard sometimes because they won't give you a service if you're not. You have to be a U.S. citizen to be accepted of some of the services that they offer. They have ingrained it, U.S. citizenship and benefits and privileges so much in modern society that it's very, very difficult to arrange your life in such a way where you will not be an acceptor of benefits and privileges. That's why Trump was trying to tear down or dismantle the government. That's what Project 2025 is all about. That's why nobody on the Democratic side of the spectrum likes Project 2025, because it's talking about making government smaller. Because when you make government smaller, you have less government spending. But that's why the Democrats always need a problem. Because as long as we got a problem, they need government intervention. There ain't no problems, you don't need for government intervention. Racism, everything's a problem. All right, so okay, so let's get back. Let's get back to dealing with presentments. All right, so now we're going to talk about, I'm going to start right here, and this right here starts discussing this creation about this bankruptcy of the United States and how you can go and kind of check some of the things out on it. It says in 1933, U.S. Incorporated declared bankruptcy as publicly noticed inter alia by House Joint Resolution 192 of June 5, 1933, Public Law 73-10, and Perry versus U.S., 1935. Now, Perry versus the United States is a very good case for you to read. That case was Perry after 1933. He tried to redeem his gold certificates for gold, and they wouldn't give it to him. And it gets into a long discussion of why they didn't have to. If you want to understand how they hijacked the money or all the gold in the United States, that is the case you want to read. Perry versus the United States. Okay? And that is the citation of authority, volume 294, U.S. Reporter, pages 330 through 381. Okay, so the result is that there is no money, namely real money, which is substance such as gold and silver coin, that pays debts and is the coin of sovereigns. There is now only the representation or symbol of money consisting of debt created against credit, appropriate for bankrupt citizens devoid of capacity. The credit used to create and back the debt currency is provided by us through having given our gold in the 1930s and our labor ever since to back the failed corporation. Among many significant consequences of this are that there are now only bills of exchange, notes, and other evidences of debt to circulate as money. All currency today is created by signature. You got to understand the importance of your signature of when you sign your name on documents. That is very important for you to understand in society. When we accept and return a presentment for value, we discharge an obligation and render the offerer devoid of a claim. This banker's acceptance utilizes our standing in law as the creditor, the source of the credit, to discharge the obligation by using our exemption for offset and adjustment. We become established as the creditor and owner of both sides of the transaction. In the past, we have usually sent the presentment back to the issuer ourselves. Now we realize that it is far superior to use a notary to send it to them. The notary does not care what is on a presentment or our paperwork or the amount involved, namely whether a document says $1 or $10 billion. The only thing the notary cares about is whether the document has a place for endorsement and a jurat, thereby justifying taking your fee, putting your document in an envelope, and serving it on the other party saying respond in 10 days. This time period is in accord with Regulation Z, Federal Truth in Lending, 15 U.S.C. 1601 XX, consisting of what? 3 days for mailing, 3 days for the issuer of the presentment to decide what he's going to do about your acceptance and return for value, 3 days return for mail, and plus 1 day for service, which does not count on the time clock. The total time is there about 10 days. And now this has changed. This 10-day time frame will change if you're dealing with something that is regulated by statute, like the Fair Debt Collection Practices Act. If you're going to do an administrative process utilizing the Fair Debt Collection Practices Act, you got to give them 21 days because they got 20 days to respond in the Fair Debt Collection Practices Act. All right, so you got to understand, are you doing a private process or a public process? You can use an administrative process on either one. That goes on, it says, we have the notary serve our acceptance and return of the presentment to the offerer. The notary's address is given for the respondent to send the check, remedy, or reply to. When a respondent does not respond to the notary within the required 10 days with a notice of discharge of the obligation, he is in dishonor of our acceptance for value. He has not adjusted the account and is keeping the account open and the charge in place, continuing to cause trouble for us and make money by stealing our exemption. When no response from the original presenter is received by the notary within the required 10 days, we have the notary issue a certificate of non-response, which is a certificate of dishonor. At this point, the dishonor of the issuer of the presentment is established on the commercial record. A notary's logbook is an irrefutable substantiation of the facts and admissible as evidence in any court. And this is why you want your notaries to have a notarial record book. Any notary that you're utilizing in an administrative process for evidentiary purposes is required to have a notary record book, because when you go into court, that's going to be an exhibit that's going to be used to help substantiate your claim. So the key to the notarial process is that a certificate of non-response issued by a notary is a judgment in estoppel. The first certificate of non-response is a judgment in estoppel on the law. The second judgment is estoppel on the fact/money. Ideally, we should do both when dealing with a presentment, since we wish not only to discharge the obligation, but use the process to better us commercially. And he's speaking right now of when they go into dishonor, usually when you draft up some sort of administrative process to discharge something, in there you're going to have a notice to them that if they don't discharge it, that there's going to be a penalty that they have to pay. And that is what you're going to be seeking when they do not discharge it. We must remember who and what a notary is. This is real good. This led me to do some research in Corpus Juris Secundii on notaries, which is where you're going to find probably the most detailed information on notary, the history of notary, and the powers that they have. Even all the powers that haven't been curved back by statute, because a notary can arrest people, marry people, do all kinds of things. We must remember who and what a notary is. Historically, the notary wrote the king's papers. He issued the writs. A public notary is higher than a judge. Okay, now how is he higher than a judge? He's higher than a judge because a notary is the keeper of the facts, and a judge can only apply law to whatever the facts are. So that's why you have to establish what the facts are first. That's why if you go into court and you don't have the facts established, then you got to go to trial. That's what's called fact finding. Trial is what's called fact finding. A judge is what's called a fact trier. A jury is called a fact trier. You can't go to the law until we know what the facts are. How can you apply the law when we don't know what the facts are? So the facts have to be established on the record first. Then the judge can come in and apply the law. And that's why a notary is higher than a judge, because the notary is going to bring in what the facts are. In addition, notaries have had from inception two primary functions. Number one, to protest international bills of exchange. This is why you see notaries in banks. Notaries in banks are not there for you. Notaries have always been used in commerce, and the banks need them to do protest certificates. All right, so to protest international bills of exchange, and two, be a bonded neutral party who holds the commercial record and can place evidence into a court of any jurisdiction. Thus, the notary, as the ultimate holder of the commercial record, is higher than any judge, inasmuch as no judge can act without the record. The great value to us is that through the notary, we can place unimpeachable evidence in a court case for the record. Okay, now, so we got some good foundational understanding of what a notary is, the powers of a notary, while we're doing an administrative process, what facts are, what the jurisdiction that you're operating in, what you have to understand, what the difference between United States and United States of America is, what cases you can read to understand the financial nature of the system. There isn't any money. We have a debt-based system. These are things, these are foundational things you need to understand before you run out there and start trying to discharge debt or start going into a courtroom screaming at someone saying you don't have jurisdiction over me. Somebody said this. Somebody said, hypothetically, if you are stopped by the police and there is no record of you having a social security card, what will happen? How are the police going to move forward with engaging you? Well, that is something very interesting. What I would tell you to do is have some documents on you and some pieces of paper to give to a police officer to explain things. Most of these police, though, they've already been told that you're some sort of terrorist on the road. What I would do if you're stopped by the police is simply comply and sign the ticket in a particular way, like corpus delicti or UCC 1-308. Just put that in the signature box, or put a coactus feci. You have forced me to do, or anything like that, because that signature line. And if you get a ticket and they don't require a signature, then you're going to do some documents out of abatement of common law, and you're going to send it to the courthouse. But the thing about it is you don't need to get into a confrontation with a police officer on the side of the road. They're not trained in any of this information, okay? But you got to understand, you have to say, well, do the police read the Constitution? They don't have to. Police need to understand what procedure is. Because the reason that they teach them procedure, as long as they follow the procedure, there will not be any constitutional violations. That's why they follow procedure. The procedure is what protects them. It holds them harmless. So let's look at this real quick. It says, it is crucial to understand the following. The commercial tribunals courts of the United States and the states are in the private equity/admiralty jurisdiction of the alleged creditors in bankruptcy, the International Monetary Fund, et al. Number two, as admiralty courts, the tribunals deal in matters of contract, in which the defendant is presumed to have contracted on land to be on the ship where the captain's word is law. One is presumed guilty unless proven innocent, and the burden of proof is on the defendant to prove that he is not guilty, namely prove a negative. Now, this is very interesting. I used to hear all the time, like David Wynn Miller and dudes like that, and say, well, you know, we're on a ship in dry dock. All right, he used to say that all the time. And so I was down in Miami, and I was looking down on this federal courthouse. And this is the federal courthouse in Miami. And as you can clearly see, it is shaped like a boat in a dock. It's a boat in a dock. You see that? That's the federal courthouse, and the grass is cut like water. But standing on the outside of it, you would never know that. They're taking you on a ship. That was incredible when I saw that, how they built that like a boat in a dock. Like a boat in a dock. That's your federal courthouse in Miami, in case you're wondering. All right, let's get back to this, all right? So we're going to get into a discussion about admiralty as well. Now, number 3, as equity courts, the ultimate arbiter of the matter is the conscience of the court, which is how the judge happens to feel that day and is not anything accessible by a defendant. There is no conclusions of law and findings of fact issued, since it is an equity, not law. Nor are there any facts, nor does any documentary material evidence exist established on the record of a case. An attorney, as we have discussed, cannot be a competent witness. Number 4, since these commercial tribunals function in a private admiralty/equity jurisdiction that does not have any capacity to access law, it cannot deal in facts, reality. It must deal on color of things, namely assumptions, color of facts. The assumptions become facts when both parties stipulate or agree that they are true. Now, that is absolutely correct. In our judicial system, facts come into appearance when both parties agree on them. This is why a prosecutor will come to you and ask you for a plea deal. He's asking you to agree on the facts. That way we don't have to go to fact finding. But you're agreeing to his facts, his distorted view of what happened. This is why you always want to put in a counter affidavit. If you can't reach an agreement of what the facts are, you got to go to trial. You have to go to fact finding. That's a dangerous place for a sovereign to be in a colorable court. We know, how do we know it's a colorable court? Because they're using colorable money. These courts all accept Federal Reserve notes. As we have just said, the Federal Reserve is an entity that exists outside of the Republic. It has to be, because the only money that can exist in the Republic is gold and silver. So it has to be operating in a territorial jurisdiction where Congress can do whatever they want to do. And to have access to that, they require you to have some sort of social security number to make it all lawful. So let's continue. Number 5, you cannot invalidate one assumption with another assumption. You can invalidate an assumption only by placing facts and evidence on the record. You have to remember they operate, you can read all through the law and everything is a presumption. Even when the attorney sends you a dunning letter, he said, if you do not answer this letter within 30 days, it's going to be presumed that the debt is valid. Okay, there's always a presumption that they're operating off of until facts can be established. And you either do that through a stipulation of the parties before you get to court, as it says in Matthew 5:25 of the Bible, agree with your adversary before you get to court. At least he hand you over to the judge hand you over to the bailiff, and the bailiff cash you into prison. I'll tell you, you will not come out until you pay the very last farthing. Okay, it's agreements that we're trying to get. That's for the purpose of doing an administrative process. And we're looking to do that either expressly or implicitly through tacit procreation. Silence is acquiescence is an equitable principle. Remember that. Okay. Number 6, anyone in dishonor in any legal proceeding has forfeited his capacity to state a claim over which relief can be granted and must legally/commercially lose if the other side remains in honor and proceeds correctly. This is why it's important to stay in honor. This is why you don't come into the court and cuss out anyone or anything like that. You always are a gentleman. You kill them with intelligence and the ability to articulate and substantiate your position. If both sides, number 7, if both sides are of a dispute or in dishonor, which is normally the case since all attorneys argue and dispute, as do most pro se litigants, whoever is ruled as the winner is a function of the judge's discretion, concerning which he has a carte blanche to proceed as he wishes. This is another thing you want to try to avoid. The places in law where judges can exercise, or administrators, the legislature has allowed them to exercise discretion. We want to get away from it, allowing them to do that. Number 8, if we can enter documentary material evidence as facts on the record and require the judge to take judicial notice of that evidence, we have a platform from which we can win, because without stipulations, the other side has no evidence, facts to support their claim. Number 9, as a result of the above, it is logical to conclude that not only must we place our evidence into court in any case in which we are involved, have the judge judicially notice it, and act in it in a way that provides us with a win, but placing evidence on the record and causing its existence to ensure that we prevail is the only reason we should ever go to court or even deal with a court. Which is true. That's the only reason you go to court, is put evidence on the record. That's it. Number 10. We must act from the beginning we must act from the beginning and as always from the purpose of setting our evidence on the record in any case in which we might have to be involved, so that we can not only win, but if we act correctly, make money, perhaps a considerable amount from the situation. All right. Now, the next logical question is, how can we place evidence on the record in a case? The following means may be deployed by entering evidence on the record. Here are the ways you can enter evidence on the record. Number one, you can use a deposition. That's when they take you into a room, make you swear under penalty of perjury, and an attorney's in there and asking you a series of questions. Number two, testimony in open court. Obviously, you can go in court, take the stand, you swear to tell the truth, the whole truth, and nothing but the truth to help you God. Number three, an affidavit. Not as good as the first two, unless one can cross-examine the affiant of the witness stand. All right? And which also you have to attest to under penalty of perjury. And then number four, entry of evidence into the record by a notary. Now, you will notice that all four of these require what? You to swear some types to God. Evidence is something that is attested to under penalty of perjury. If it's not, it's hearsay. And something that is attested to under penalty of perjury can be cross-examined in an attempt to impeach that evidence. Of all the above cited methods for entering evidence into a case, the fourth method, the notarial process, may be the most desirable. By doing so, one may enter the evidence one chooses by means that must be admitted as evidence on the record, which no court can refuse to enter, and do so preferably without having to endure the time, effort, and expense of depositions and attending court proceedings. We must always remember the following, okay? Number one, stay in honor and never dishonor anything or anyone, including police officers, judges, even attorneys. Your opponents must go into dishonor of their own volition. Number two, put the issuer of a presentment in a position of having to put up or shut up, namely, place the burden of proof on him. Remember, there is a maxim of law. The burden of proof is on he who asserts, not he who denies. They have to prove their case, not you. Number three, establish all documents substantiating our claims on the record of the notary and the evidentiary record of any court case involved with the transaction. Number four, relate properly with everyone involved, especially the court and the judge, so that you can make the best of your situation, namely prevail and also make money. And you do want to learn how to correspond with a judge and not be offensive, with your correspondence. Just be professional. Treat everything as business, and you should be okay. Don't take offense, personal offense. Leave your personal feelings out of it. The more you can do that, the better. Number five, this is a very important one. Do not talk for any reason that does not serve your interest, and be prepared as much as possible to know what you wish to accomplish, what not to allow to happen, and the proper way to say what can succeed in achieving the results you desire. They must have your words, your admission, and even your legal determinations to hang you. Anything you say can and will be used against you. Ain't that what they did to Jesus Christ? Let's go and see if we can trip him up in his words. When they asked him that tax question, render to Caesar what is Caesar and what is the Lord to the Lord, first thing they said, when we go get him, we're going to see if we can catch him in his words. Anything you say can and will be used against you. So the safest form of communication to use in a court is questions. That way you're not admitting or denying. You're looking for clarification, which usually you have every right to do, because everything they say is vague, because all the words they're using have multiple definitions attached to it, like even the word U.S. citizen. If they ask you, are you a U.S. citizen, could you please define U.S. citizen and tell me and this court where you derived that definition from? Because I've been looking for it and I can't find it. So why would you admit to something you can't find the definition of? Let's continue. So the tangible steps / process / documents involved in dealing with any presentment consist of several phases. Number one, execution, filing, and notice of foundational documents stating rights, standing, and capacity. This is what you would term your status correction documents. But you need to have something on the record noticing them in every process that you do in dealing with a court. There has to be something that's going to notice them of what your status is and what your standing is in the court. It's called standing judicio, standing in court, and rectus in cure, right in court. You have to be a real party in interest with standing in court. So what is your interest in the matter? Usually, like in federal court, your interest is you're coming in under Rule 24, which is a third-party intervener. Because there's property that they're seeking to attach, which is your straw man. That's not you. That's your estate that they're attempting to attach. That's why you're a third-party intervener. You're intervening into something. And your standing is your capacity as the creditor, as a private citizen with standing in the Republican form of government. And the evidence that you put on the record should substantiate that. 2, administrative actions concerning the presentment, both pre-court and non-court. 3, documents and dialogue in court. You need to know what to say in court. You have to perfect your ability to talk in court. You need to spend a considerable amount of time practicing on things to say in court. You got to do that. Number 4, if the issue is a mortgage, securing both legal and equitable title to the property as well as right of possession must all be done. Right of possession is very, very important. Possession is 9/10 of the law. The other 10th is honor. Did you pay the taxes on it? Do you have the equitable and legal title associated with it? This is necessary. You really need to study, like a lot of you Moors out there who squat in houses, it's just ridiculous. You need to learn real estate investing techniques. You always get the deed. You don't go into no house or try to obtain any house without getting the deed. And there are easy ways of making that happen. When you got the deed, nobody can say anything to you. The first step in getting the deed is just asking the owner for it, which means you need to be able to find out who the owner is. And that is usually found in the tax assessor's office. If the property is abandoned, that means somebody don't want it. If a property is abandoned, it usually means a couple of things. If they still have a mortgage on it, that means it's a liability because that's not making them any money. It's also is subject to some sort of vandalism, which can cost them some more money. They have to pay property taxes on it. Maybe they're out of state. The owner of it, the parents died, and the children are out of state and they don't want it. Abandoned properties have stories behind them. So the first thing you need to do is communicate. If you can't get their phone number, write them a letter and be patient and wait. They say, hey, look, we don't want it. Say, well, would you be interested in quit claiming that over to me? I'd like to rehab it or something like that. Or maybe even offer some money. If look, I'm gonna give you $1,500 if you quit claim the deed over to me. Something like that. So let's look at this last paragraph. In the event they ignore everything we do, we can proceed to collect from them by a number of possible means, including non-judicial strict foreclosure. Write that word down, non-judicial strict foreclosure. You have self-help means within the UCC. As outlined in Chapter 9 of the UCC, we can also instigate a bankruptcy proceeding. That would usually, bankruptcies like that are involuntary bankruptcy, which is issued by the creditor, not the debtor. When bankruptcy first started, 90% of the bankruptcies were filed by the creditor. Today, almost 100% are filed by the debtor, not the creditor. That's an interesting history of bankruptcy that you need to study as well. If you're going to be looking to use bankruptcy in any capacity, like involuntary bankruptcy, you need to understand that. They are delinquent creditors, and we can request that an offset be performed that results in our collecting against their bonds, equity, or risk management department. Okay, and that's it for Chapter 2. Next, tomorrow I'm going to do Chapter 3. It's going to be criminal and civil charges. That's going to be tomorrow. Okay? Man, we got 820 people in here. Maybe I need to keep going. How long have I been going? Oh, it's 8:44. Okay, well, you know what I'm going to do? If y'all give me some donations, I will keep it going. If I get some donations, y'all want me to keep going? Let's see some donations come in. I want to see how bad y'all want me to keep going. There's 840 people in here. Yes, I am lobbying for donations because the donations are thin today. Hey, it's thin. I'm like, damn, where are all the donations? Y'all ain't enjoying the program today? My Cash App is HFRNGMG. I got a new Cash App. My new Cash App is, where is my, that's my Cash App right there, HFRNGMG. If y'all want to Cash App me, that's fine too. All right, so okay, I guess I will keep going. I appreciate that, Pandora's Croon. $2. I appreciate that. Thank you very much for the two bones. Appreciate that. Appreciate that. Appreciate that. John Krabowski, another $1.99. I appreciate that. I appreciate that. Thank you so much. Thank you, thank you, thank you. Let's see what else we got in here. Can I snitch and not face Big Homie in court? If you're a snitch, you need to face whomever. I don't know. I think you're a snitch. You know, if you're a confidential informant, they're going to air you out anyway because they don't respect you. I appreciate the gift of the eternal 10 bones. I appreciate that. Thank you. Thank you. Project Awaken X, appreciate that. The transmission, appreciate that. Alvin Carr, appreciate that. The $4.99, I appreciate that, bruh. Deanna Daniel, I appreciate you. Thank you so much, baby, for the 10 bones. Dope Seed, 9 to the 9th power of 9. I appreciate the work you put in. I appreciate you too, my brother. I appreciate you too. All right, okay, we got some donations going, so I'm going to continue. I'm going to continue. All right, appreciate you. All right, so let's look at civil and criminal charges since y'all want to keep going. Okay. Whenever you receive a traffic ticket, citation, summons, complaint, indictment, etc., what you receive is a public offer. It is an offer of indebtedness to your strawman. It is conclusive presumption, namely fact, that your strawman is obligated to provide the funds if you act in dishonor. In commerce, the penalty for being in dishonor is losing one's equity. Remember that no court in the system, since they are all in the public realm, can see, address, or deal with the real you. Public courts can deal only with the assumptions and fictions in their colorable, phony system. As such, there are no facts other than what is stipulated, agreed to by the parties. If an adversary says the sky is green and you agree, the agreement constitutes a fact. The commercial tribunals of the system are all contract courts, and your stipulation is contractual ratification, which is the law of the matter. People lose in the courts because they try to counter or neutralize one assumption with another, and that is true. A lot of people try to neutralize an assumption with another assumption when you go into court. You have to have facts. Everything is about stipulation, which is why an administrative process and learning how to do one properly is so important. If you are in dishonor, you will be forced to provide through your strawman public funds, Federal Reserve notes or an equivalent, one way or other, to satisfy the obligation. This can be by simply parting with Federal Reserve notes, doing community service, or by being incarcerated as the surety for the obligations of your strawman. In the latter case, they create the bond by further borrowing against your strawman. This generates funds that are used to balance the books and also make considerable additional money for the courts, judges, attorneys, etc. There is a video on the internet. It's called the Judges Slush Fund. You should watch that because it shows they did a Freedom of Information Act request and found out that all these courts in California, they're private trading companies. Who actually owns these courts? They're their own. They have EIN numbers. They're privately owned. This is no joke, y'all. Y'all can verify a lot of stuff that's being said if you take the steps to go and verify it. Shirley, I think her name is Shirley Moore. If you go over there and watch that video, she did the Freedom of Information Act request. Very, very eye-opening information about and what she was doing. She was going at Child Protective Services. And she found out that, who the courts were. They are for profit. That is what a court registry investment system is. Those case numbers are CUSIP numbers. It's a lot of stuff I'm trying to tell you. If you're in dishonor, okay, let's go to the next. Okay, it says, this generates funds that are used to balance the books and also make considerable additional money for the courts, judges, attorneys, etc. Given the immensity of the money made per the CAFR and LAFR reports, which is several times the total amount of the entire economy of the private sector, the mania in the United States for charging, prosecuting, and incarcerating is understandable. The following are important considerations in the equation. Number one, as investors in the bankrupt corporation called the United States, and you are an investor in the United States, you're a preferred investor, a preferred stockholder. As investors in the bankrupt corporation called the United States, as well as the United States of America, the parent corporation, we as real people are the true creditors of the country and source of the wealth, as discussed above. As such, we are exempt from taxation from the public side. And now notice he said exempt from the public side. You can't be in the public and be exempt from taxation. You have to be outside of the public. This is how you learn how to do this, is by one of the best ways in learning how to to exercise private rights is learning how to administer a private trust or understanding the tax laws. The tax laws will teach you how to stay private, because everything in the public is a tax, because everything in the public is a benefit and a privilege. Because if you weren't taking anything from the government, you wouldn't be in the public. Public means government. Public school, funded by government. Public welfare. Public policy, that's government. So if you don't want to be taxed, you got to learn how to stay out of the public, or learn how to use an entity to operate in the public, such as a corporation, which the public is designed to accommodate and receive benefits for doing business in the public, called write-offs. This is all business, man. First, you got to understand public and private. Don't take this nowhere else it doesn't need to go. All that Moorish stuff and all this right to try, don't take it there. This is business. It always has been. The first video I watched on this was the Occult World of Commerce, which Jason Whitney and Jordan Maxwell. And he says all just business. And I've truly come to understand that statement. Jason Whitney, if you're watching, I understand, bro. So let's read this again. As investors in the bankrupt corporation called the United States, as well as the United States of America, the parent corporation, we, as real people, are the true creditors of the country and source of the wealth, as discussed above. As such, we are exempt from taxation from the public side. The creditor and sovereign cannot be taxed by a system that functions by using the credit of the creditor. The public side is debt operating by borrowing against us. Being derivative and dependent, the tail cannot wag the dog. The reflection cannot dominate the reality it reflects. The system does not deal with us as real beings. The system does not deal with us as real beings. It deals with a fiction, a symbol, which is not us, and therefore does not require the system to deal with us as the creditor and sovereign. Moreover, the public domain can tax and regulate only what it is created in and belongs to the system, which can only be the straw man and never real beings. And this is very important. This is where this all caps name comes in, which is their creation. They can regulate that. That is their property. They created it. When you're doing a process, you're not doing a process to own the straw man. You're doing a process to control the straw man by controlling your labor. Your labor is what you have owned. And you're taking an ownership interest in that labor by filing a lien against your labor first. So you're first in line, first in time. So if anybody else comes along and tries to make a claim against your labor, you will simply notice them by providing them with a UCC1 that you already have a priority perfected interest in your labor. Let me see if we find. I appreciate the 10 Bones, Tome 374. Appreciate the 10 Bones. Timothy Reiser, appreciate the 5 bones, bro. Yusef insight on surrendering driver's license. You don't need to surrender your driver's license. You don't need to surrender. I'll talk about that. You don't have to surrender your driver's license. Once again, like I said, all that's not a part of this process. We're dealing in commerce. The driver's license was not issued see, they use the driver's license to presume that you have agreed to operate under all the statutes. You can rebut that. George Mercier has a process that talks about that in invisible contracts, the Armand Kondo letter. If you're interested, you're really interested, do a search of that document, Control F, and put in driver's license, and go and read out an entire section what he's discussing on there. I was planning to do a video on that, because it's never been like that. See, the reason why when you file a UCC-1, the driver's license number is claimed on there is because by having a driver's license, when they give you a ticket, that's a claim against your labor. But you already have a priority perfected interest claim against that. And that's what that's why you're putting the driver's license on there and noticing them of that fact. It's your labor that you're putting the claim against, not none of these things that belong to them. They utilize those things to access your labor. Use of Presenments video 2, you brought up the location of the United States on UCC 9-306, and it was defined inside brackets, so it isn't supposed to be ignored and only used for content. No, it's not ignored. Why would you ignore it? Anything in the box, he's trying to use that, anything in the box is not there. Okay, so you ignore it. Does that alleviate the fact that it's a corporation? Is that what you're saying? I'm not understanding what your point is. Because if it's true they're supposed to ignore it, then why put it there in the first place? Why put it there in the first place? UCC 9-307, location of the debtor. I did post my new Cash App. Y'all didn't get it again? Let me get it again. My new Cash App is $HFRNGMG. That's my Cash App, HFRNGMG. Appreciate that. Appreciate that. We got a lot of people in here today. I got a lot of people in the chat today. Let me look in the chat real quick and answer some more questions. It says United States is, it says, my guess is because the United States B was dissolved and literally does not exist in this capacity. The court version of the USA-USB is the federal What does it matter? So what? All that stuff doesn't matter. Because you can't deny it because you're still using Federal Reserve notes. And you still have something out there called a U.S. citizen. I don't care about any of that. They can call whatever they want to call. The thing is, you're using something that belongs to them. And they can regulate that. What you want to call it, that's not even relevant. That's not even, that doesn't have any bearing on anything. People get caught up in things that are insignificant. That don't have any bearing on anything. What is that if something's been repealed, the fact is you're still using Federal Reserve notes. Y'all still signing I'm a U.S. citizen on documents. Let's see. All right, let's go. Let me read this again. The following are important considerations in the equation. Already read that. Let's look at number 3. The size of the purported obligation as well as its severity is technically irrelevant. That which can be invented in the form of an alleged obligation can be offset, namely discharge, with the same ease as the obligation was created. All public debt is nothing but numbers, digits in a matrix. Promissory notes creating currency by signature got us in this mess, and promissory notes can get us out. Now, this is something that I always read, this footnote right here. This was an important footnote. Y'all need to read this because this right here taught me the difference between mala prohibita and malum in se. Okay, so it is often considerably more difficult using the acceptance for value process for dealing with matters involving a mala in se crime than a mala prohibita offense. Although all crimes in the system today are commercial crimes, see 27 U.S.C. 72.11. Now, what does that mean? So let's take some time to look up the word malum in se and malum prohibitum. Those are important words for you to know. So let me pause for a second and let's take some time and let's look up those words. Let's look up those words. Let's look them up. All right, we're on SPC University. And right here under the dictionaries, going to go to Black's Law Dictionary. And let's go to the 8th edition. Now, malum in se means evil in itself, and malum prohibitum means prohibited conduct. But let's read them, though, because on that movie True Grit, you said that little girl, she knew the difference in malum in se and malum prohibitum, and she was 13 years old. You should be ashamed. She knows it and you don't. So we have, let me do control find malum. So right here, malum. So that's malum prohibita, malum praxis, malum in se right here. See malum in se. That's malum in se. So malum in se. Right here, malum in se. Malum in se, Latin. A crime or an act that is inherently immoral, such as murder, arson, or rape, also termed malum per se. The basis for the distinction between malum in se and malum prohibita, between what one might call a crime and an offense, or between what one might call a felony and a misdemeanor, if one could modernize those terms so that the latter was given its natural meaning, is that the crime means to the ordinary man something that is sinful or immoral, and an offense, at worst, a piece of misbehavior. The distinction between offenses malum in se and offenses malum prohibita was recognized at least as early as the 15th century. It has been criticized repeatedly. About a century and a half ago, the distinction was said to be one not founded upon any sound principle and which had long since been exploded. Other citations omitted. The Supreme Court, however, has shown that it is just as firmly entrenched today as it was in 1495. So then we have malum prohibitum, which is right here, an act that is a crime merely because it is prohibited by statute, although the act itself is not necessarily immoral. Misdemeanors such as jaywalking and running a stoplight are malum prohibita, as are other many regulatory violations. Much of the criminal law that is regulatory in character, the part of it that deals with malum prohibitum rather than malum in se, is based upon the principle that the choice of the individual must give way to the convenience of the many, and that is that the good for the what's good for the many overrides the good of the few. Customarily used, these phrases are mutually exclusive. An offense malum prohibitum is not a wrong which is prohibited, but something which is wrong only in the sense that it is against the law. This is emphasized at times with such phrases as malum prohibitum only, or but malum prohibitum, although it is understood without any such qualifications. A failure to understand this usage of the terms has led some to assume that all statutory additions to the common law of crimes are malum prohibita. One writer emphasized this confusion by speaking of embezzlement as malum prohibita. This assumption is utterly without foundation, as an act may be malum in se, although no punishment is provided by law. If this defect is corrected by appropriate legislation, what previously was malum in se does not cease to be so by reason of having been defined and made punishable by law. Now, I don't know about any of that. That's supposed to be expert commentary, and I don't agree with that shit. How does he substantiate that? Now that was large basically off of, because they statutory codes, they are malum prohibitum. It's prohibited conduct. They're not common law. They're not operating in the common law. This is when these new dictionaries, you got to really watch what they be saying. And you got to take, I don't agree with what he just said right there. Not at all. Hold on, let me go back to the... Appreciate CO Records, the 9 to the 9 power of 9. I appreciate that, Doc. Okay, so what do we got? Finally caught alive on Presenments. How do I present my claim in a way so they don't ignore me after filing affidavit of truth and ownership? Well, I mean, you got to get a court date. What do you mean ignoring you? They ain't Filing paperwork is not doing anything. When you file paperwork, you're just noticing the court what you're intending to present in the evidence. Y'all, that's another thing I don't know where y'all getting is y'all think y'all file paperwork, somebody's ignoring you. No, you need a court date. Or you need to get the judge to rule on something. Like, what are you asking for? You know, are you seeking summary judgment on something? Have you filed a claim on something? Have you filed a lawsuit? Are you the defendant or the, you know, I need to know those things. The plaintiff or the defendant. That's a very, very vague question. Very vague. What if you don't have a lien on your straw man? Don't you still have priority interest on your labor? No, because you didn't give notice to it. That's what UCC wanted. You got to follow the rules. You can't make up your own rules, bro. You're going to operate in commerce. You're going to play the game. You got to follow the rules of commerce. You don't have to ask me a question. It already tells you what if you ain't filed it. And all the answers are in the instructions. You got to give notice. If you don't give notice, no, you don't have a priority perfected interest. That's why it's called perfected. Perfected means you took the necessary steps to substantiate your claim. You perfected that interest. Priority perfected interest. All roads lead to court. That's right. That's right. And we got 1,040 people in here. You know, I don't know. But anyway. All right, y'all. Look, I'm going to end right here. And we're going to come back tomorrow. I got to end it right here. We're going to come back tomorrow. We're going to complete this thing. I hope you got something from this. I hope you were able to garner some nuggets of information. From today's lecture, okay? And the reason I do this is because I'm just trying to give y'all a very good foundational understanding of a lot of things, showing you what you can learn if you read these documents. You can learn some things. We have a lot of people complaining about people charging for information. You don't have to be charged for information if you'll take time to read, if you take time to read the information. You know, I am making some very more intensive training videos on SPC University. You know, it's a lot of work involved in all of that. While I'm doing that in the interim, I will be on YouTube teaching and telling you things at no charge so you can get an understanding of this information. It is a lot of information to go through. It is not easy to understand, but if you take the time to, you know, just take your time. Take your time. Don't be in a rush. But you can't come here looking for a quick fix. You can't say, I got a court date next week. Yusef, can you help me? No, I can't help you, man. I can't help you. You got a court date next week? No. No. You know, that's a setup. That's a setup. You trying to set me up. That's a setup. No, I can't go with that. I can't go with that. I can't go with that. What we got in the chat? Okay. I appreciate all the donations today. For the donations that we're getting. I appreciate any amount of donations. You know, give $1.99 or $100. I appreciate the donations. I always do. All right. Thank you so much. Okay, I'm going to get up on out of here. I want you to like, comment, and subscribe. I'm interested in what you think about this video. Please put your comments down in the comment section of this video. And I will see you on the next live. Peace to the gods. See you tomorrow.